Good day, Crime Talk aficionados. We have a great show for you. First, Alan Jackson tries to double down for his old client, Nick Reiner, and he's the master of the obvious. Trial begins in the au pair fetish plot. Potential challenges against Dr. Michael McKee, the man accused of killing his ex-wife and her new husband. A Chicago man extradited for charges in regards to his wife's fatal fall from the 24th floor. Oops. The judge has had enough of the delays and sets a firm trial date in the Gilgo Beach serial killer case. An Oklahoma mother is sentenced to life in prison for a fatal crash that killed 5, including 2 of her own children. A Kansas man is charged with first-degree murder in a little neighbor dispute. I hate neighbor disputes. We've got this day in legal history, our quote of the day explaining the role of the judiciary. And wait until you hear what our dumb criminals stole and for what reason. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications, and you can go check us out on any of your favorite podcasting apps. Let me quickly remind you, we are going live tonight, 6 p.m. Mountain Time. We'll be talking about all of the cases in the news today, and we'll obviously enjoy your input as well. Let me also remind you to go to crimetalksearch.com, sign up for that background subscription service today. When you do, you'll be able to do as many background searches as your heart desires on anyone here in the United States. The report is literally prepared while you wait. It is emailed to you, and it can even be updated once new information becomes available. Also, you're going to be able to find out about people and their social media contact, whether they have numerous email accounts, for those dating sites that they don't want to tell you about. And you're going to find out about their social media history. You're going to find out if they're married, divorced, whether they have, to register on a sex offender list, and whether they have a criminal history. Go to crimetalksearch.com, sign up today. You're going to be happy that you did. All right, ladies and gentlemen, let's do one more announcement before we get to the docket for January 13th of 2026. Crime Talk Vault Episode 1 is live. Watch and interact to have a chance to be included on the special episode coming soon. We're also going to do a trivia show. So we're going to have trivia applications and check it out. All right. Check out the YouTube community page for more information about that. That's right. Compete. See if you truly are a true crime aficionado, of your knowledge of true crime, and there could be cash prizes. Just saying, cash prizes. All right, let's go ahead and open the record for Tuesday, January 13th, 2026. And first on the docket, Alan Jackson. Yep, that's right. Alan Jackson is back, even though he's not even on the Nick Reiner case anymore. That's right. The prominent defense attorney who recently withdrew from representing Nick Reiner in the double murder case involving Reiner's parents, Rob Reiner and Michelle Singer Reiner, has reiterated his public statements that Nick Reiner is not guilty under California law. Wow. Of course he is presumed not guilty. That is a statement, a factual statement under the law, which is absolutely correct. What's he going to say? Oh, yeah, I think he's guilty? No, of course not. Anyway, speaking on the Hot Mics podcast with Billy Bush, Jackson stood firmly by his courthouse remarks made after formally withdrawing from the case on January 7th, and he emphasized that his declaration was grounded in fundamental principles of the U.S. legal system. The presumption of innocence. That's right. Under the laws of the state of California, he is not guilty, Jackson stated. What I said is the truth. He explained that his statement was intended to counter widespread public speculation and to clarify that until proven otherwise in a court of law, every defendant, including Nick Reiner, is legally not guilty. Now remember, the presumption of innocence enshrined in California law and the United States Constitution requires the prosecution to prove guilt beyond a reasonable doubt. And no defendant is considered guilty simply because charges have been filed. I agree with Alan Jackson on that, but I mean, that's like the master of the obvious type of statement, okay? But he did it at the time for flair. He did it for headlines. He wasn't just, oh yeah, under the law, he's guilty, or he's He didn't just say under the law, he is not guilty and given the presumption of innocence. He said it emphatically, which, of course, he is making an accurate statement. But come on. Let's be realistic, ladies and gentlemen. Nick Reiner is entitled to the presumption of innocence. But the reason why people want to know and hear about from Mr. Jackson was the very thing he declined to elaborate on. And that was the specific reason for his withdrawal, citing only circumstances beyond our control and ethical constraints that prevent further disclosure. He stressed that the reason for stepping aside do not alter his belief in Reiner's legal status or his ongoing commitment to Reiner's best interest. Now, for those who don't know, Nick Reiner faces 2 counts of first-degree murder in connection with the stabbing deaths of his parents, whose bodies were discovered in their Brentwood mansion on December 14th of 2025. Reiner was arrested hours later near the University of Southern California and remains in custody at the Twin Towers Correctional Facility. He is now represented by a public defender and is scheduled for an arraignment on February 23rd of 2026. And if convicted, he faces life in prison without the possibility of parole and potentially the death penalty, which is about slim to none in this particular case. Now, like I said, while Jackson's statements have fueled some discussion about possible defenses, including the potential of a plea of not guilty by reason of insanity, such a finding, if successful, would not equate to acquittal or release. Under California law, a verdict of not guilty by reason of insanity typically results in commitment to a state psychiatric facility until the individual is deemed no longer a danger to themselves or society. And as a reminder, the Reiner family has declined to provide further comment, expressing only trust in the legal process. We'll continue to follow that one, ladies and gentlemen. I'm sure Alan Jackson, whether he's on the case or not, will be there to let us know his thoughts about it as well. We'll obviously continue to follow the case of Nick Reiner, and we'll see if the public defenders remain on the case. Somehow, I think they're going to. I think it's not that the estate or the family of Mr. Nick Reiner doesn't have the money to pay for a high-powered defense team. I think they're just choosing not to. Next on the docket, the trial begins in the Virginia double murder case involving a little fetish plot. The trial of Brendan Banfield commenced today in Fairfax County Circuit Court on charges of aggravated murder in the February 2023 death of his wife, Christine Banfield, and Joseph Ryan at the couple's home in Herndon. And according to prosecutors, it is alleged that Banfield orchestrated an elaborate scheme to eliminate his wife so he could pursue a relationship with the family's au pair, Juliana Perez Magalhaes, with whom he had been engaged in a month-long affair. Now, according to the prosecution, Banfield created a false profile on a fetish website, posing as his wife to lure Ryan to the residence under the pretense of a consensual sexual encounter. The plan, they assert, was to stage the scene to appear as though Ryan had attacked Christine, allowing Banfield to kill him and claim self-defense. Now, Banfield has pled not guilty to all charges, which include 2 counts of aggravated murder with the use of a firearm in the commission of the murder and a charge of child abuse and neglect, the latter stemming from the presence of the couple's 4-year-old daughter in the home at the time of the incident. Now, what did opening statements bring? Well, some stark difference in narratives, that's for sure. In her opening statement, lead prosecutor Jenna Sands directly accused Banfield of orchestrating both killings. She said the evidence will show that Brendan Banfield planned and executed the murders of his wife and Joseph Ryan. Sands told the jury of 16 members, 9 men and 7 women, including 4 alternates. And the defense attorney, John Carroll, countered that the case against his clients relies heavily on testimony from the au pair, whom he described as having been subjected to significant prosecutorial pressures. Now, Carroll claimed investigators offered the au pair increasingly lenient plea deals, including one that would have reduced her charge to a misdemeanor in an effort to secure her cooperation against Banfield. Well, the au pair, who moved from Brazil to work for the Banfield family in 2021, has pled guilty to manslaughter and is expected to testify as a key prosecution witness. In fact, as we were starting to film this, she had taken the stand. Now, early testimony and evidence proceedings began with testimony from a 911 dispatcher and one of the first responding officers. Jurors heard the recording of Banfield's emergency call in which he reported shooting an intruder who had stabbed his wife. During the playback, Banfield was observed wiping tears from his eyes. Officer Zach Beckner testified that Banfield had visible blood on his hands upon arrival at the hospital, but was permitted to wash them before samples could be collected. Becker explained that he had not restrained Banfield and allowed and washing out of empathy, noting he had received no specific instructions to preserve the evidence. Took their afternoon recess and then resumed, and they heard testimony from the Assistant Chief Medical Examiner, Dr. Megan Kessler. And what we do know is that the killings occurred back on February 24th of 2023. Christine Banfield, an ICU nurse, was found stabbed multiple times in the couple's bedroom. Ryan, who had no prior connection to the family, was discovered nearby with fatal gunshot wounds. Initial statements from Banfield and the au pair described Ryan as an intruder who they shot in defense of Christine. However, investigators later uncovered communications on the fetish website FetLife that allegedly linked Ryan to the address through the deceptive profile. Now, the case has drawn, obviously, quite a bit of attention due to its unusual circumstances, blending some elements of a little infidelity, online deception, and, of course, they've thrown in a little violent crime. The proceedings are ongoing with further testimony expected throughout the week. You can actually watch it here live on CrimeTalk, ladies and gentlemen, so go check it out. Now, obviously, the outcome will determine whether Banfield spends the rest of his life in prison if he's convicted on the aggravated murder charges. Well, we got a whole lot of killing going on here, ladies and gentlemen, but let's talk about Dr. Michael McKee, the man accused of killing his ex-wife and her husband in Ohio. So, a couple of potential challenges in the evidence against Michael McKee, the vascular surgeon accused of murdering his ex-wife Monique Tepe and her husband Spencer Tepe in their Ohio home back on December 30th of 2025. So, McKee was arrested on January 10th of 2026, 11 days after the shooting following a multi-state manhunt. Police traced his vehicle to the crime scene, where it arrived shortly before the killings and departed soon afterwards. The vehicle was later recovered near his workplace in Rockford, Illinois, about 325 miles from the victim's home. Now, the delay in apprehension gave the suspects significant time to dispose of or sanitize potential evidence. Very Brian Koberger-esque, is it not? Anyway, and obviously the good doctor, being a medical professional, is familiar with forensic science, including DNA analysis. And Dr. McKee would likely have been aware of common evidentiary traces left at a crime scene. This extended window raises questions about the integrity of the physical evidence that might otherwise have been removed immediately. However, most individuals who commit homicides have no prior experience, increasing the likelihood of errors, like, driving your own car to the crime scene. In particular, footwear impressions discovered outside the home are expected to be critical focus for investigators. And any shoes in McKee's possession at the time of the arrest have likely been seized for forensic examination, specifically for gunshot residue and comparison with prints at the scene. As you may recall, the victims were discovered after a colleague of Spencer Tepe, concerned by his absence from his work at Athens Dental Depot, requested a wellness check. A friend who arrived at the home reported hearing the couple's young children, ages 1 and 4, crying inside. The children and the family dog were found unharmed. So McKee and Monique Tepe were married from 2015 until their reported amicable divorce in 2017. Apparently not so amicable. Apparently somebody didn't get over it. Fortunately, they had no children together. Police have not publicly disclosed a motive, though relatives of the victims indicated that they anticipated McKee's involvement. Well, McKee faces 2 counts of murder and is awaiting extradition to Ohio for further court proceedings. Next, the man's being extradited back, because they believe he participated in her fall from the 24th floor. These things happen. I'm sure it was an accident. Adam Becker, Inc., a 47-year-old man, has been formally extradited to Cook County, Chicago, and charged in connection with the death of his wife, Caitlin Tracy, who was discovered at the base of a stairwell in their South Loop condominium building. Police allege that Becker Inc. threw Tracy over the railing from the 24th floor, resulting in fatal injuries and the severance of one of her feet. He faces counts of first-degree murder and murder with strong probability of death or great bodily harm. Now, Becker Inc. was returned to Chicago on Monday after serving slightly more than 3 months in a Michigan facility. He had been extradited there in March of 2025 to address separate domestic abuse allegations involving Tracy. Following Tracy's death, a legal dispute arose over the disposition of her remains, with her parents prevailing in court against Becker Inc.'s claims. Now, the court records show that Tracy secured an order of protection against Becker Inc. in Cook County back in November of 2023, prompted by multiple prior reports of domestic violence to Chicago police. Now, Tracy's mother, Monica Tracy, has described her daughter as a dedicated, intelligent woman who was deeply cherished by those who knew her. In earlier statements to media, she expressed profound grief over the alleged prolonged abuse, saying that she and her husband now visit their daughter's grave instead of sharing meals with her. No form of justice can erase our suffering, she said, restoring her life or erasing the physical and emotional trauma inflicted by this individual, referring to the ex-husband. Anyway, a detention hearing originally set for Tuesday has been postponed to Friday at the request of Becker Inc.'s attorney to allow additional preparation time. Needless to say, he's going to remain in custody pending those proceedings. Next, the judge in the Gilgo Beach matter is at his wit's end, and the delays will end. So the Suffolk County judge presiding over the high-profile Gilgo Beach serial murder case expressed sharp frustration Tuesday with ongoing pretrial delays, declaring that the trial of accused killer Rex Heuermann will proceed after Labor Day 2026, regardless of remaining obstacles. During a hearing, Supreme Court Justice Timothy Mazzei emphasized his determination to move the case forward after more than 2 years of legal proceedings. This trial will begin after Labor Day. Come hell or high water, the judge stated. The remarks followed the late Monday filing of additional defense motions by Heuermann's attorney, Michael Brown. Now, the new submission contests approximately 20 search warrants used in the investigation and seek to suppress certain evidence on consensual grounds. For those who are not familiar with Mr. Rex Heuermann, he is 62 years old and he was an architect, and he faces charges of murder of 7 women whose remains were discovered along remote coastal areas of Long Island between 1993 and 2010. All of the victims were sex workers who advertised services online and vanished after meeting clients. Now, prosecutors allege that advanced DNA analysis links Heuermann to the deaths of Valerie Mack, Jessica Taylor, Megan Waterman, Melissa Bartholomew, Maureen Brainerd Barnes, Amber Lynn Costello, and Sandra Castillo. Key evidence includes genetic materials recovered from a discarded pizza crust and an energy drink can allegedly discarded by Heuermann's daughter. Now, Heuermann was arrested back in July of 2023 outside his Manhattan office. Initially charged in 3 killings, he was subsequently connected to 4 additional victims through forensic DNA evidence. Now, the defense attorney has argued outside court that the collection of DNA from discarded items raises serious Fourth Amendment concerns. If the government can retrieve DNA from our trash and obtain comprehensive personal information, the protections intended by the Fourth Amendment are undermined, he is arguing on the courthouse steps. Although that is a faulty argument. You have no expectation of privacy to discarded things. Anyway, the attorney rejected suggestions that the defense is intentionally prolonging this case, stating, "We have been working diligently and we will be prepared for trial by Labor Day." The district attorney welcomed the judge's directive and reiterated that his office is ready to proceed. He also confirmed that there are no plans to offer a plea agreement. While acknowledging the volume of defense motions as typical in complex cases, the prosecutor said he does not believe the filings are designed to create deliberate delay. Anyway, back in September of 2025, the judge ruled that the DNA evidence obtained through the investigation is admissible, delivering a significant victory for the prosecution. Now, the case obviously has lots of attention as one of Long Island's most notorious unsolved serial killer investigations until Huerman's arrest revived hope for some resolution. Next, an Oklahoma mom is going to prison for the rest of her life. That's right, a 30-year-old Oklahoma woman has been sentenced to life in prison after causing a February 2024 collision with a fire truck while driving under the influence of cocaine and marijuana, resulting in the deaths of 5 people, including 2 of her own children. Please meet Keosha Rucker. She pled no contest to multiple counts of manslaughter and driving under the influence. The crash occurred when Rucker, who was transporting her 1-year-old son, 5-year-old daughter, 23-year-old Tamia Ray, 4-year-old Michaela Lynn Chapman, and pregnant 26-year-old woman, failed to yield to an oncoming fire truck responding to an emergency with lights and sirens activated. And I would note, remember, a no contest plea is a guilty plea. You can say no contest, but it's treated as a guilty plea. Remember that. According to police, the fire truck driver attempted to pass Rucker's vehicle using an open lane, but Rucker turned directly into its path, causing the collision. The impact killed Rucker's 2 children, Tamia Ray, Michaela Lynn Chapman, and the unborn child of the 26-year-old passenger. Now, Rucker and the pregnant woman survived, though Rucker sustained severe injuries resulting in partial paralysis on her right side. Surprisingly, police recovered cocaine and marijuana from the vehicle, and toxicology tests confirmed recent use of both substances within 12 hours of the incident. Now, during the sentencing hearing, prosecutors presented evidence, including a recorded jail call in which Rucker expressed no intention to stop using drugs. The judge, citing a lack of remorse and the severity of the offense, imposed 5 life sentences, structured so that Rucker must serve at least 40 years before becoming eligible for parole. And Rucker has separately filed a lawsuit against the city of Tulsa and the Tulsa Fire Department, alleging negligence on behalf of the fire truck driver, right? Because she turned into the fire truck that had the lights on, and it's the fireman's fault, according to Miss Rucker. Can't make this stuff up, ladies and gentlemen. I hope the city doesn't settle just even nuisance value for that. Next, a Kansas man gets charged because of a little neighborhood dispute. A 41-year-old man shot and killed Monday morning in the Northland neighborhood in Kansas City following a confrontation with a neighbor, according to police. The suspect has been charged with first-degree murder. That suspect, Jeffrey Travis King, has been charged with first-degree murder and armed criminal action in connection with the homicide in the 2500 block of Northeast 78th Street. The victim was identified Tuesday as Chris Wells. Court records detail a sequence of events that began around 7:30 a.m. when Wells' wife encountered King while walking the family dog. Due to the existing no-contact order and a reported history of King harassing her and other neighbors, she returned home and called her husband. Wells, who had been at work, returned home and confronted King. Surveillance video reportedly captured Wells punching King, followed by a physical altercation. The footage then shows Wells walking away with his hands raised, and that's according to the arrest affidavit. Now, gunshots followed shortly afterwards. Wells' wife told police she did not witness the shooting, but found her husband lying on the ground and began calling for help. Wells was pronounced dead at the scene. An autopsy revealed he had been shot not once, not twice, not 3 times, 13 times, including 8 wounds in the back. 2 juvenile witnesses told investigators they saw King stand over Wells, who was lying face down, and fire multiple shots. Now, after the incident, King reportedly told another individual that Wells had attacked him, prompting him to shoot him dead. King was taken into custody, and during a subsequent search of his residence, detectives recovered a note bearing Wells' underlying last name and a reference to alleged destruction of my property. Anyway, the Kansas City Police Department investigated the shooting with the support of the Clay County Sheriff's Office. Self-defense, huh? 8 shots in the back while the man is on the ground. That dog don't hunt, ladies and gentlemen. That is not going to work out well for Mr. King. Next on the docket, this day in legal history, January 13th, 1794. The Flag Act of 1794 was enacted. And what did it do? Well, that law updated the U.S. flag design, most notably moving to add 15 stars and 15 stripes after Vermont and Kentucky joined the Union. In an early example of federal law formally defining a national symbol as the Republic expanded. On this date in 1964, the United States Supreme Court ruled in Anderson v. Martin. The court invalidated Louisiana's requirement that ballots identify each candidate's race, holding it violated the equal protection by encouraging racial discrimination in voting. It's an important milestone in voting rights and equal protection from the civil rights era. On this date, back in 2004, Illinois v. Litster, the United States Supreme Court upheld an information-seeking highway checkpoints to ask the public about a recent hit and run. The Supreme Court determined that checkpoint was reasonable under the Fourth Amendment. It's a key checkpoint case distinguishing brief informational stops from general crime control roadblocks. Next, our quote of the day. One of the most foundational statements on the role of the Supreme Court comes from the landmark case of Marbury v. Madison, decided in 1803. That case was authored by then Chief Justice John Marshall. And the quote is, "It is emphatically the province and duty of the judicial departments to say what the law is." Now, this declaration established the principle of judicial review, affirming the court's authority to interpret the Constitution and invalidate laws or execute actions that conflict with the Constitution. This decision remains a cornerstone of American constitutional law, underscoring the judiciary's co-equal status among the branches of the government. And finally today, our dumb criminal of the day. Wait till you hear what this woman stole and why. So a 29-year-old recreational center supervisor faces misdemeanor theft charges for allegedly pilfering a coveted 40-ounce Stanley tumbler from a coworker, reportedly because she believed it would be an ideal vessel for storing breast milk. Adriana Moss was arrested Sunday in connection with the December 29th incident at the Highland Recreational Complex in Largo, Florida. According to police, surveillance footage captured Moss repeatedly eyeing the light blue insulated cup valued at approximately $60 before slipping it into her lunchbox and walking out of the facility. Police say that Miss Moss, who supervised staff at the center, had interacted several times that day with the 22-year-old owner of the tumbler and watched her drink from it. A fellow employee told officers that Moss pointed at the cup on the office cabinet and remarked, quote, "This cup would be great to hold my breast milk," end quote. 3 days after the alleged theft, Moss resigned from her position and had no further contact with the facility. Following the arrest, Moss was booked into the Pinellas County Jail and released the same day after her husband posted a $150 bond. Why? That's a little more than double what it would cost to buy that tumbler on her own. Anyway, what a weird culture that the Stanley brand, whose oversized tumblers have achieved near cult status in recent years, apparently enough to inspire at least one alleged workplace heist with a distinctly personal motive. Can you imagine stealing a cup and it was going to cost you $150 to get out of jail? Hire yourself an attorney, lose your job when you could just go buy the damn tumbler yourself? And the other question that comes to mind is, how much time did the police spend reviewing over the 3 days where this interaction took place, right? Viewing, oh, look, she's eyeing the tumbler. I'm going to steal the tumbler. How much police work went into that? Unbelievable, ladies and gentlemen. But hey, it'd be great to hold her breast milk. All right, that's all we have for you today, ladies and gentlemen. Thanks for joining us. Remember, join us tonight, 6 p.m. Mountain Time, for our Tuesday night live program. Have a wonderful day. We'll see you tonight. And remember, the Constitution matters.